So again, welcome to today's Human Rights Conversations. The Human Rights Conversations are a series of events hosted by the Geneva Human Rights Platform aimed at discussing contemporary issues and challenges related to the promotion and protection of human rights. Debates that take place online now in Geneva, but that address the human rights crowd in Geneva and beyond. So it's really trying to also broaden the discussions beyond Geneva. And I think for today, this is very much working. My name is Felix Kirchmeier. I'm Executive Director of the Geneva Human Rights Platform and will be your moderator for the next hour and a half. So today's discussion focuses on minority issues and universality. Universality, so the notion that international human rights law protects all individuals worldwide, that all rights apply to everyone, everywhere. Universality has been a key principle of the legal framework of human rights since that was enshrined in the preamble of the Universal Declaration of Human Rights in 1948. However, even right then at the time, there was an academic debate around universality, and neither states nor scholars have ever ceased challenging these principles on normative and political grounds. We have a project here at the Geneva Academy which aims taking stock of and contributing also to a better understanding of the various criticisms on universality, but also questioning the validity or the real meaning of those criticisms and their origins. To do so, our research focuses on relevant practice and associated discourse, in particular in multilateral fora, for example, around minority issues, as we're discussing today. So ahead of the 14th session of the Forum on Minority Issues and as a part of the above-mentioned research project, the Human Rights Conversation aims at exploring how measures aimed at the effective protection of minorities and vulnerable groups could take into consideration the seemingly competing narratives between collective rights and individual rights. In other words, we will reflect today on the principle of universality of human rights and associated challenges in specific relation to the advancement of minority issues at the United Nations. For that, I'm very pleased to have with me online today an excellent panel. We have, and I'll introduce them also when they speak one by one. We have Alexandra Gray, Chancellor's Postdoc Research Fellow at the Faculty of Law at the University of Technology, Sydney in Australia. Yanis Fotakis, Human Rights Expert at the Permanent Mission of Austria to the United Nations in Geneva. Fernand de Varenne, United Nations Special Rapporteur on Minority Issues. And Joshua Castellino, Executive Director of Minority Rights Group. In terms of the setting for our discussion today, I would suggest to give the floor, first of all, of course, to the panelists for some interventions of some 5, 7 to 10 minutes maximum for a presentation on the topic. Before then, we'll move into a discussion with all of you who have joined us today online. Giving the floor to the panelists, I'd also invite all of you actually to reflect on some general questions of how do minority issues manifest themselves through language rights? How should human rights narratives respond to different types of risks faced by different people or different categories of people? How should we reconcile competing narratives around the principle of universality, given the political tensions they create within multilateral fora, and also whether actually we can have more than one narrative around universality, and if so, how can they be reconciled or what should prevail? So our first speaker today is Alexandra Gray, who, as mentioned, postdoctoral research fellow in Sydney, Australia. And Alexandra's book, Language Rights in a Changing China, a national overview and strong case study of 21 was recognized as one of the best dissertations on the sociology of language internationally through the 2018 Joshua Fishman Award. Currently, Alexandra researches the law and policy framework behind the Australian government's use of languages and other than English in public communications, including in COVID-19 communication and the role of the state in Aboriginal language renewal. So very much an issue of universal human rights, rights to culture also, and very much a minority and a protection issue, as we see with the language and language renewal, so also active role of a government. So Alexandra, over to you for your presentation. The floor is yours, please.
Thank you, Felix. And I just want to thank you at this point and the Geneva Academy for the invitation. As you've read out, my research is very relevant, I think, to what we're discussing today. And it's a great pleasure to have a chance to speak to people who are interested in this issue. Customarily in Australia, we begin with an acknowledgement of country. So I'll just share my screen very briefly to show you what I'm saying here. Nini Nalawangun Mari Badjuri Gadi Nurida. So this is, I acknowledge that I'm on the beautiful country of the Gadi people, the people of the Eora Nation in Sydney, Australia. And I'll leave the screen up briefly and just show you the book that I'm going to give an overview of here. I thought for this audience, it might be useful for me just to begin by outlining the study, which is the basis of my invitation to participate today, and some of the key findings in a short overview. So Felix has already given you the title, and as you can imagine then from it, the book is not about linguistic human rights all over the world, but very specifically in the Chinese context. Some of you will know that within China, there is a huge degree of linguistic diversity. There are many people who speak not only varieties of Mandarin, of which you might be aware, such as Cantonese, but also a whole suite of languages not related to Mandarin, which are spoken by groups of people, some minorities in the numeric sense that we might recognize as very small groups, similar in size to minorities, say, here in Australia. The Zhuang group, who I focus on in my study, is in fact the biggest recognized minority people in China and number somewhere around 17 million, about 1% of the population, or about 1/8 of all the non-Han population. And so that in numeric terms might not seem like a minority, but of course in the Chinese context still is numerically and then also politically and in terms of power, very much a minority. So this book that I will be basing my comments today on is not really just about language at all. As you might have picked up on, I'm actually based in a law school, and my scholarship is a combination of sociology of language and law. So this is a book really about the legal, social, political and geographic organization of China, the PRC, in a time of great change this century. And it uses language as a way in, because for those of us here who are focused on minority issues and particularly linguistic issues, we might think about language a lot, but in a more general sense, I think language is often there and not noticed. And so it can be a wonderful route in to all these other aspects of politics and society and law that are happening when we choose to use that window or that route. So the book starts from the premise that there are constitutional language rights in China, and there have been over the various forms of the constitution back to 1949, when the People's Republic was founded. And these are found in Article 4 of the Constitution, and they are specifically for minority languages. And it is phrased as a right, or sorry, as a freedom to use and develop minority languages. So from a legal perspective, you can think of it as a negative right. Now, in the international scholarship on minority language rights or on minority issues in general, there are various ways of looking at who is a minority. It's relatively flexible depending on the context in which that group of people live. But in the Chinese constitutional sense, a minority is a very rigidly defined group of people. There are 55 ethno-linguistic groups who are recognized minorities. And 54 of those have a language which is recognized as the emblematic language of that people. So in the case study that I'll be talking about, the Zhuang people are one of these recognized groups, excuse me, and associated with a language called Zhuang, which is in the same family as Thai, the language of Thailand, or for those of you who are linguists, in the broader group called the TAI, Thai languages. Now, what I wanted to know in my study was how these linguistic rights, which appear in the Chinese constitution, operate today. And not only how they operate legally on various levels, central, regional, local government levels, but how they are received and made use of or understood by people in China today. So in a, if you like, discursive sense, which is quite relevant to our discussion of narrative today, what is the discursive understanding of a language right? And what particularly piqued my interest in this question is that these Chinese constitutional language rights arose in the mid-20th century, right around the same time, and as an outcome of similar international discussions as produced the international language rights that we focus on. Albeit here, these are not in an international treaty, but in a domestic constitution. And yet, although they have this long history now in China and this association with a broader international understanding of language rights, there has been very little legal change in these rights over the last 70 odd years, although, as you're all aware, China has undergone enormous political, economic, social, legal changes in that time. So my question was not only how are these language rights working on the different levels that I mentioned before, but how are they working in a way that has adapted or has not adapted to the current circumstances? And so very briefly, to understand that problem, I used a combination of analysis of law and policy documents from about, which I collected from about 2013 to 2019, but which of course date back over the history of the PRC. And then in addition, I did an ethnography. So that is a sort of participant-focused type of fieldwork. Focused on 6 different places in China where Zhuang people live, and particularly focusing on a group of 43 university students from Zhuang speaking or Zhuang ethnic backgrounds and 20 community leaders. And not exclusively, but within my Zhuang case study, a particular focus was on an area called the Zhuangzi Autonomous Region, or Guangxi Zhuangzi Autonomous Region, which is like a province of China on the southern border with Vietnam, but under the titular autonomous rule of the Zhuang minority. So just to very briefly give you an overview of some of the key findings that might be of interest to the group today. The first is that law does not operate in a positivist way. What the study very clearly shows is that law does not always operate as intended or as is written, but in fact is a very, I feel like, malleable affordance that's taken up by some people, by institutional and community and individual actors to different ends in different contexts. What I also found is that there are no new high-level laws about minority languages, although there has been an increase over the last 20 years in legislation protecting and promoting majority language rights. So that is the right to use and be educated in Putonghua, the national standard version of Mandarin. However, at the regional level, there has been new legislation about public display of Zhuang and of various activities to do with documenting and preserving Zhuang. What I also found is in the Chinese legal system, these minority language rights from the Constitution do not create structures or processes or entitlements for either individuals or groups to enforce or protect their language rights. So in that sense, this constitutional language right is more like a compass, which I know is a word used in some of the background papers to today's discussion and in discussions of international law more generally. They're more of a normative compass than a legal mechanism. Nevertheless, at least in my study, I found that a belief in the existence of a minority language right and the corresponding awareness that there is a sense of justice in being able to use or having some protection of one's language is very much something that is affected by the presence of that right in law, even if that right in law is not legally especially effective. And even if people do not specifically understand what that legal right does or is. Another thing that perhaps doesn't need to be said, but I think should be said, is that people, even today, even in the modern context where Mandarin and English are very important and very economically advantageous, even in that circumstance, people still care about their minority language, Zhuang. They care about whether other people speak Zhuang. They care about whether people will stop speaking Zhuang. They care about how Zhuang is part of their heritage and their identity. And so people are still passionate about the language remaining a lived part of the culture, even though at the same time, many people are faced with challenges and decisions in their own homes about passing on the language to their children. And even though there's very, very little access to schooling in Zhuang. And so we have this shift away from Zhuang language at the same time that people still believe passionately that Zhuang language is important to their individual and group identity. Another finding that's particularly interesting, I think, because it's probably not just specific to my study, is that although Zhuang is now in the last 10 years increasingly put on street signage in certain areas under Zhuang autonomous rule in China, and on various other sorts of public texts, many Zhuang speakers do not recognize it as Zhuang and cannot read it. So that really speaks to a problem with literacy in Zhuang, and also with a problem, as I put it, with the normative emplacement of Zhuang. People do not expect to see Zhuang in a public built environment and have not learnt how to read Zhuang or even to recognize it as a script, even if they are Zhuang speakers. And so that really cuts to the heart of a sense that governments often have in China and elsewhere, that if you put a language on display, it valorizes that language. It gives that language more public presence and more positive associations. But if that is not met with corresponding policies that enable people to recognize and read and value that language as that language, then it's not doing what it's supposed to do. And then the last, just to summarize a big part of the findings of the book, is that the laws, the constitutional minority language rights and the laws at various levels that derive from them are largely, even the new laws at the local level, are not adapting to face or to challenge the problems that arise in the current circumstance with the urbanization and marketization and globalization going on in China. So continuing to speak Zhuang in everyday life, in education and professionally at work, and to use Zhuang as a positive identity resource or an in-group marker, that is becoming increasingly difficult. And so language rights are not doing very much to help people. And although there are many structures, as I'll put up here, this is a governance chart that I have made in the book of all the different organs of the state that are in some way responsible for the management or governance of Zhuang language. Although there is, in a formal sense, a lot of structure here, in fact, a quite fractured and complicated structure, there is not a sense of accountability or responsibility or agility that enables these bodies to respond to those current challenges and to use language rights in a way that is meeting those current challenges. And I can't say whether that is from apathy or ignorance or deliberateness. However, what I can say is that rather, and this is my last point, rather what we see is that the right to use and develop minority languages is increasingly being interpreted in regional and local and even national laws and policies into an obligation on the state to assist people document and make artifacts of their language, which can be kept in museums. So this raises its own problems that I raise in the book, this idea of a nationalization and a depersonalization of cultural heritage. So I'll leave it at that.
Thank you. Thank you very much, Alexandra, for that presentation. Indeed, taking us into, well, me at least, also into some local languages that I wouldn't have known otherwise. So thank you for that. And I think also interesting to hear that you say language rights do not help many people. So it's really the question then of how the interpretation is going, what the right itself does, and what its malleable nature, as you put it. So thank you very much for that intervention, and I'm sure we'll come back to that in the discussion. Let me turn to our second speaker, to Yanis Fotakis, a human rights expert at the Permanent Mission of Austria to the United Nations in Geneva. And since 2015, Yanis is in charge of negotiations of the Austrian-led Human Rights Council resolution on the rights of persons belonging to minorities. Previously, he has worked as human rights expert at also the delegations of the European Union to the United Nations in Geneva and in New York. And so, Yanis, what challenges do you encounter, say, in the informals leading up to those resolutions? And where do you see actually then, if we just heard that sometimes the law doesn't do the whole deal, so where do those resolutions also bring minority rights and the protection of minority rights? So the floor is yours, Yanis.
Thank you very much, Felix, for your kind introduction. And I should say that I'm very happy to be in this panel with such distinguished experts on minority issues. As you said, I will focus mainly on the state perspective. I will give you a little bit of an insight of what the main challenges are that we're encountering in our efforts to promote the minority rights at the United Nations. And maybe I will, if I have time, I will also try to tell you a little bit how we try to navigate around those challenges. At the outset, I should say that the question of universality is absolutely central, and it is particularly important also in the context of minority issues, given that if the principle of universality were to not apply, then probably the first victims would be the ones who are most marginalized, which unfortunately in many cases are persons belonging to minorities. Now, despite as you said in your introduction as well, a general agreement on the concept of universality, it is indeed true that it has still been over many years an issue where there are disagreements on how exactly this applies in practice. And there are still different opinions about the specific meaning about it. And this is something that we feel very strongly in the Human Rights Council as well. I would say across the board of all negotiations, irrespective of the topic. And the most common objections that we face to universality are questions around cultural and religious relativism. So to what extent certain human rights are compatible with some cultures. We feel that, for instance, in the negotiations on minority issues, by the insistence of many states to always mention the four categories of minorities in a way to make sure that it could not be interpreted as also including sexual minorities, which of course is still a taboo issue in many states. But also whenever we speak about gender dimensions and women's rights. Another very common objection is around the issue of development and to what extent poverty and other economic criteria could be hampering the ability of states to promote and protect certain human rights. And of course, the question of security and to what extent security can justify a non-compliance with human rights. However, in the case of minorities, if I had to choose one major challenge that we are facing in our negotiations, it is the fact that there's still a perception among many states where minorities live that minorities pose a threat to the territorial integrity of the state. And as a result, there is a general reluctance to accept any standards or measures that would actively promote diversity. So that would go beyond the prevention of discrimination to actively promote diversity, and even more so when we are speaking about collective rights, for instance, for minorities. Now, this interpretation of the link between territorial integrity and protection of minority rights is actually in complete contradiction with what the Declaration on Minorities says, which is still the key instrument that we have at the UN level, at least, for the protection of minorities, which explicitly states that the promotion and protection of the rights of minorities contributes to social and political stability of the states where minorities live in. And I think what this shows to a certain extent is how important also the political circumstances are in which such negotiations take place, bearing in mind that the Minorities Declaration stems from the early 90s, at a time when there was growing recognition about the importance of protecting minorities, also in light of the collapse of states following inter-ethnic conflicts, such as in Yugoslavia, for instance. Now, a second debate I would like to mention, which is also very much linked to the question of universality, formal universality in a way, is related to the objection that many states have in the Human Rights Council with regard to the mandate of the Human Rights Council to address country-specific situations. And the principle of universality is often used as an argument to oppose such initiatives, and the claim that country situations should only be used in the context of the Universal Periodic Review, which is a mechanism, an examination which every state has to go through every 4 years. Yet these resolutions, these country resolutions, they're absolutely crucial also in the context of minority issues, because they address crisis situations and conflict situations. And as you will all know, minorities are disproportionately affected in conflict situations and disproportionately targeted and most vulnerable. And we also need to bear in mind that these resolutions serve often the purpose to establish monitoring mechanisms such as commissions of inquiry or fact-finding missions, which can also be instrumental in preventing human rights violations. So if the Council were to address country situations only during the Universal Periodic Review, it would almost never be able to react to emergency situations, which would have a detrimental effect also on minority rights. Now, the final challenge I would like to make, I would like to present is very timely also in light of the Minority Forum starting tomorrow. And it has to do with the participation of minority representatives at the work of the United Nations. I would say that the establishment of the Minority Forum in 2007 has been maybe one of the biggest breakthroughs that we've had in our efforts to promote minority rights at the United Nations, because it is really the only platform at the UN where minority representatives have the opportunity to participate in the work of the UN, to attend and to present their challenges and recommendations to governments. And yet the participation of minority representatives is unfortunately still very much disputed, and anyone who has attended the forum will have witnessed that the atmosphere can at times be relatively loaded, and that minority representatives are often interrupted during their interventions and their accreditation being challenged. And I would just like to make the point here that we consider it absolutely essential for the realization of universality, that the voices of those who are most vulnerable are heard, and it is also something which is essential in terms of making the work of the United Nations more relevant in terms of not being too detached from what is happening on the ground. Finally, if I still have a couple of minutes, I would just mention a few of our initiatives and also how we try to navigate a little bit around these challenges. And I should start by saying that basically we have to compromise a lot. We have chosen to take a consensual approach to a topic which can be quite political, unfortunately. And we have done so essentially because through these resolutions, what we're trying to do is to elaborate standards. And states are feeling mostly bound by standards that they have agreed to. Therefore, consensus is important. Yet we always have to move forward, and sometimes the progress that we're making is painfully slow. But the important thing is that we do not by any means fall beyond what we already have, and essential documents such as the minority declarations provide us a very good baseline in that regard. The second point is that we of course need to continue fostering the participation of minority representatives at the work of the United Nations. Austria provides financial support to the Minority Forum, also in order to facilitate the minority participation. And we also particularly welcome the initiative that the Special Rapporteur has taken in recent years to also organize regional fora, which really is another means to further broaden participation, in the sense that not everybody has the means to travel to Geneva, and also to bring regional realities into the work of the United Nations. And we see enormous potential in that. And we also see enormous potential in virtual formats, which have which we have discovered over the last 2 years now, and which also provide really a fantastic tool to broaden the participation at the work of the United Nations. And finally, my final point is that we also need to continue maintaining the topic high on the political agenda. And Austria has, in its recent resolution at the United Nations a couple of weeks ago, mandated the General Assembly to organize a high-level debate in the margins, or in light of the 30th anniversary of the adoption of the Declaration on Minorities, which will take place during the high-level segment of the General Assembly, and which will provide a fantastic opportunity for states at a high level to reaffirm their commitment to the standards of the Declaration. I will leave it at that for now, and happy to come back if there's any questions later, in case I can answer them. Thank you.
Thank you. Thank you very much, Yanis, and congratulations, obviously, also through you to the permanent mission and actually to Austria for that initiative that you're spearheading and leading since quite a while. And also thank you for pointing out forward-looking opportunities for reaffirming political support from all sides. And I think what you said about active representation resounds a lot, because I think when we talk about universality, also it's not just who is universally covered, but who can universally participate. And some years ago, we also had a research project looking at the UPR, which is obviously for good reasons hailed for its universality, but looking in what even states, what small states actively contribute, sometimes beyond their own review, made universality look a little bit more questionable than overall. I think also you're mentioning the issues of relativism in like cultural relativism, but also exceptionalism in terms of development or security concerns is quite interesting, because it also links to, I think, different regional groups that are advancing those themes. So universality is under stress and tension, say, from different perspectives and also from different groups. I think that's also an important point to retain. I will not comment more, but we'll get back to you also in the discussion later on. I think also, and well, that's maybe also a point that leads over from your intervention to the next speaker, because if I'm not mistaken, the declaration was adopted without a vote. So there is universal recognition of the declaration, but then how it's upheld, how it's interpreted is maybe far from universal. So I'm happy to turn now to the next speaker, Fernand de Varenne, since 2017 Special Rapporteur, UN Special Rapporteur on Minority Issues. I don't necessarily have to present you to the audience here, but let me still say that, well, you're the reference point there also for the protection of human rights and of national or ethnic, religious or linguistic minorities. And I think a big basis of your mandate, obviously, is the declaration, but also going beyond the UN context. Let me mention, as we are also in an academic setting, that you're an extraordinary professor at the Faculty of Law, the University of Pretoria in South Africa, a adjunct professor at the National University of Ireland, and Cheng Yu Tung, visiting professor at the Faculty of Law in Hong Kong. So I think there too, there is quite some diversity in your academic career, also leading maybe to specific views on universality, how you perceive it then when teaching with students of the different regions. So very much looking forward to hearing from you, and the floor is yours, Mr. Varenne.
Danke schön, Felix. Merci beaucoup. Bonjour tout le monde. Guten Tag. So allow me to express my gratitude at being part of the human rights conversation today, hosted by the Geneva Human Rights Platform and the Geneva Academy. And of course, as well as the pleasure of being on the same panel as Alex, Joshua, and Yanis. I'm also delighted to be here to explore the intimated tensions between minority issues and universalism, and also the underlying assumptions of what I would call majoritarian normality and of minority exceptionalism. Conceptually, minority rights are human rights, including in the area of language, just as much as the rights of women, the rights of children, the rights of indigenous peoples, and the rights of Afro-descendants are human rights. The rights of women, minorities are not in tension with universalism, because they are simply put the concrete applications of the general human rights that were first enshrined in the 1948 UN Declaration, Universal Declaration of Human Rights. I'm always perplexed how this is sometimes, however, misinterpreted and misportrayed, usually from those who come from majority backgrounds, as to somehow minorities and other groups, as somehow they are trying to seek a competing narrative, or they're applying a competing narrative, that they want special or separate treatment. Muslim or Jewish minorities in Europe, for example, are not seeking what we could call in French un cadre exceptionnel, or un cadre d'exception, but they're not trying to operate outside of the universal framework provided by the post-World War II human rights architecture. What does seem to occur sometimes, however, is that the majoritarian views and values, particularly in Europe, I might add, become normalized and universalized to the point that it is assumed that minority, religious, linguistic, or cultural preferences are, quote, outside the norm, unquote, and that these challenge the supposed universalism of human rights, à l'européenne, in the European style. Philosophers such as Canadian Will Kimlicka and Israeli Yael Tamir have astutely pointed out that no state is completely neutral in terms of religion, culture, or linguistic preferences. In all of the world's countries, states favor more or less exclusively or explicitly one or a few languages, for example, to be used by the government in the interactions and services to the public. They also often emphasize national unity through a common national culture. And in a surprisingly large number of countries, they also have an official or state or some kind of privileged religion, as a matter of fact. And even countries, states such as the United States or France, which are, these states are presented as secular. In fact, laïcité has become almost an official non-religion. But in fact, they're not religiously neutral, since in the case of both of these countries, Christian holy days, such as Easter and Christmas, are designated by law as public holidays, whereas no holy days of any other religious tradition are. So they often view the majoritarian state's norms and institutions as, in fact, the norm, the normal. Now, two very brief examples, I think, would illustrate the point here. There are, for example, the direct contradictions between the conclusions of the European Court of Human Rights in a number of cases on ostentatious religious symbols and practices, such as the wearing of a headscarf in France and a few other countries, which are directly and diametrically in contradiction with the conclusions of various United Nations human rights mechanism. And there is, secondly, the frankly, I would say to be somewhat controversial, the rather shocking conclusions of the European Court of Human Rights in relation to crucifixes in public schools in Italy having no religious dimension. Universal human rights, to make the point clear and simple, are agnostic in terms of religion, language, and culture. But the examples I just gave to you suggest that some of the European human rights mechanisms are not applying the agnostic dimension that is inherent, is supposed to be inherent in universal human rights. But let me use the event I participated in Ireland last week in relation to the travelers, a minority community with affinities, links to Romas in other parts of Europe, to explain why conceptually minorities are not seeking un cadre d'exception, and that it is not a tension between the grievances and claims of minorities and the universality of human rights that is in play, but rather in different parts of the world that majoritarian nationalism or majoritarian control of the institutions of the state is subverting human rights standards to defend and advance their own identities and specificities to the detriment of a truly universal application of human rights standards for all. And that this occurs particularly to the detriment of certain minorities. In Europe, there is, to give a specific example, the infamous case of the European Court of Human Rights known as Chapman versus the United Kingdom, where Roma and travelers in the UK were refused permission to live in a caravan on lands that they actually owned. Now, some of you may even know this case well, but to summarize very quickly, the European Court recognized that the Roma and travelers had different housing and other needs. Their needs are different from, partially because of their cultures and traditions, including their way of life from those of the majority. Now, remember that I mentioned that the international human rights system is agnostic in terms of language, religion, or culture. Unfortunately, the European Court is not quite as agnostic as we are in some of these issues. For one thing, the majority of the court described the lifestyle and housing needs of the Roma and travelers as special and, in a sense, distinct or outside the norm of those who compose the majority population of the UK. And the different needs of a minority, when you portray them as special, implies that the needs of the majority or the interests of the majority in housing are normal, and that all the others are peculiar. Now, on the one hand, many observers in Europe thought that this was in fact a great victory, because the court did say that special housing needs are legitimate as part of the right to private and family life. So there's a dimension here that seems universal, but in the application, in this case, there is an approach which actually is contradictory to the universalism of human rights. The court approached this in a way which did not conform with the principle of universality of human rights, because in a way it took from Peter to pay Paul, to use a colloquial expression. by admitting that while there had been an interference in relation to the travelers in Roma in the enjoyment of a home, as well as with private and family life, connected to the traditional way of life for Roma and travelers. He then went on to say that the interference was necessary in a democratic society because the land inhabited by the Roma was the subject of environmental protection, and that really the United Kingdom had a great deal of discretion on how to deal with this kind of an issue. The human rights of the traveler in Roma were in a sense not so important, and the British officials knew best on how to deal with such matters and decided that the court should not apply the human rights of the Roma and travelers in this case. So let me be provocative and insist on what the end result here is. The European Court of Human Rights, through what is called the doctrine of the margin of appreciation, decided that in a free and democratic society, that universal human rights are not universal in the case of the traveler in Roma minority communities, because in effect, it decided that it would not consider whether their right to private and family life had been impinged. Let me repeat that. The court actually decided not to apply the European Convention of Human Rights in this particular case, partially because of the margin of appreciation. This is not the universal application of human rights. And as some of you said, some have observed, this decision can be given a positive spin, but I do not. In the United Nations system, the result would not have been the same as with the European Court, because human rights are universal, and I would repeat, agnostic. And in this particular case, that is not the approach of the European Court of Human Rights in relation to minorities. In fact, a number of observers have pointed out that when there are cases involving minorities that are considered by the European Court has a tendency of raising the issue of the margin of appreciation, which means that it does not apply the convention as such. So we do not have, there is a fundamental problem here in the sense that the universality of human rights is being denied quite often when it comes to minority cases reaching the court. In the United Nations human rights mechanism, we do not recognize that states have discretion. We do not recognize this so-called doctrine of margin of appreciation when deciding that sometimes some human rights can be ignored. We simply do not have that approach. The universality of human rights is still applied within the United Nations system. I might have gone beyond this panel's time constraints, but in the spirit of being challenging and provocative, and to return to what is perhaps the type of reflection being sought on the principle of universality of human rights, there has been, I would suggest, with this example, a hijacking of universalism to equate to majoritarian preferences or majoritarianism. And this is perhaps one of the greatest impediments to the advancement of the human rights of minorities in Europe, as a matter of fact, and more certainly politically and diplomatically, if perhaps a bit less so legally at the United Nations. And I think just to connect with what a few points raised earlier by Yanis, next year is 2022 is the 30th anniversary of the Declaration of the Rights of Minorities of the United Nations. And perhaps this is a perfect opportunity to reflect a little bit more how the universality of human rights, particularly the human rights of minorities, is actually quite often misunderstood and misapplied. And that therefore we need to actually consider these matters and perhaps reinforce the human rights mechanism, particularly in relation to minorities, because of these misunderstandings and misapplications that in a formalistic approach to what are universal human rights. where the majority interest in language, religion, and culture are preferred, and those of minorities are misunderstood and quite often denied as such. Merci beaucoup, danke schön. I'll stop there so as to not take too much of our time.
Vielen Dank, merci, and thank you very much actually for that intervention, and going a little bit beyond time, I think is fine, because it's really great to hear those both the thematic and conceptual discussions, but also obviously underlined with real world cases and situation. And I think what you said in terms of the hijacking of the concepts might also bring us back partially again later in the discussion to linguistic question of universalism versus universality. And I think there's a lot in that about misinterpretation and political use, obviously, of concepts, which, as you point out, in the European court context might go beyond just linguistic or political to legal use of one concept over the other. So thank you very much for that presentation. And let me turn now to our fourth speaker before then coming to the open discussion, to Joshua Castellino, Executive Director of Minority Rights Group. Directing big NGO devoted to that issue, but actually you also have a background in journalism, and also you founded the School of Law at Middlesex University in London, UK, where you still retain a law professorship, and you hold also academic visiting positions in Poland, the UK, and Ireland. You are on the board of civil society organizations in India, Netherlands, UK, Hungary, and Italy, among others. So we see also quite a universalist, let's see, approach, and also in your personal activities. And I'm very pleased to have you with us on the panel today to speak on, well, minority rights and their relation to universality, the underlining of universality, as we heard before, also the threats of universalism, misused universalism, misguided politics against minority rights. So let's hear what's your take on all that. And Joshua, the floor is yours.
Thank you very much, Felix. I really appreciate the fact that you're holding this academy and focusing on this issue. And it's been a pleasure to share the platform with Alex, Yanis, and Fernand. I had prepared some specific answers to the 4 questions, but I think in the spirit of trying to get this debate moving forward, let me build and let me start on what Fernand finished on, which I absolutely endorse 100%. Colleagues, this notion of universality is in fact majoritarianism, trying to now find excuses for why it is that minority rights should not have lex specialis. And we should not buy into this. And I share the perplexion that Fernand expressed in why this is something that we should be talking about in 2021. So let me address that particular aspect and give you some, I guess, examples from practice, because Minority Rights Group, we are active in 53 states at the moment, and we have 38 live projects, many of them that are cross-regional. So this could be a question really addressed at an organization like us. Let me also acknowledge that in our own history of 52 years, there has been, and there have been recently, since the killing of George Floyd, accusation of us being an organization that promotes white saviorism and that promotes solutions developed in the North that are going to be applied in the South. In other words, we are at the cutting edge of this question in our daily lives and in our daily attempt to frame projects. So I'd like to provide perhaps a practice-oriented element to the challenge that Fernand set us, that we really have to pick up in the context of the 30th anniversary declaration. The cultural relativism debate is an interesting one, and certainly growing up in India, I grew up with the idea that human rights was a Western tool that was trying to impose neocolonialism on ancient civilizations. There were reasons for that particular narrative, and I would argue that the reasons for that particular narrative were on both sides. On the side of Western activists, and forgive me for using this in a very loose sense to illustrate a point, on the side of Western activists, it was a belief that progressive realization of rights would eventually give us better societies. But the tone in which this was framed was often patronizing and was often making the common mistake, which is that you take a European experience and you assume it to be universal, and then you talk from that European perspective to others who start realizing that your perspective is very European. And so this becomes a little clash. And instead of focusing on the message, we start focusing on the messenger. And this is the classic, another colloquialism for non, throwing the baby out with the bathwater became the standard practice. On the other side, what this cultural relativism debate did is it empowered majorities who were determined to have their say now that colonization has ended, to shape their societies, to protect their interests. They may have given some accommodation to certain minorities who were close to power, but they were not really motivated necessarily by the building of vibrant societies that respected diversity. Again, a massive generalization, varied tremendously and varied tremendously by leader. You had Nyerere and others who were very much engaged in a diverse agenda, certainly on the Indian side, Nehru and others, but then you had others who were not really interested in that aspect. So the reason I point that out is that the cultural relativism debate, two iterations of it in the past. One was the so-called full belly argument made by African states, which was a critique of the human rights system, which said, you in the human rights system with your full bellies can talk about the right to vote. We, with our empty bellies, need to think about the right to food. You in the human rights system don't focus on economic, social, and cultural rights. Therefore, your system is not applicable to our realities. That was one argument. And in a sense, human rights responded by that, reiterating the indivisibility of rights, and now building a much better edifice on socioeconomic rights. And by the way, that's still work in progress. The other aspect, the Asian values debate, and I wrote about this in early 2000, was an attempt by Mahathir Mohamad and President Lee Kuan Yew to suggest that all of this stuff is Western imperialism, and essentially us Asian people are not really interested in those kind of political democracy systems. What we are interested in is socioeconomic rights. Interestingly, of course, there's not much in common when you talk about Asia between Japan and Jordan, other than they start with a J. So the idea that you could speak for Asia itself was perhaps an Asian imperialism. But the reason I start with this is because I really felt that the human rights movement had debunked these myths. And this is why I share Fernand's perplexity that here we are in 2021 engaging with this question. Let me also put on the table a slight warning here. We have had intellectual exercises within our field that have been very critical of our movement of human rights. I'm referring to Samuel Moyn and others. And those have been perspectives that have been very much driven by a specific experience of being based in the North and seeing human rights applied in all kinds of settings where they don't fit very well. But instead of recognizing the practice elsewhere, we have assumed that our limited experience is in fact universal, and we've engaged in an academic critique that has then published a lot of books and created a lot of energy, but it's also destroyed the brand of human rights. The impact of the destruction of that brand of human rights is it's been picked up by others who are exactly as Fernand said, interested in generating majoritarian regimes who have said, this human rights stuff, look, it's all nonsense. Even the human rights people are saying it's all nonsense. So I would really call upon us as a community of scholars, activists, practitioners, whatever else we might be, to take responsibility for our actions when we easily pander to these kinds of notions, because ultimately we fail the movement and we fail vulnerable groups. So let me leave that aside now. And let me also focus now directly on the question. And I want to acknowledge in the audience is our new special rapporteur also in the field of cultural rights, Alexandra Zantaki, who herself is a scholar of minority and indigenous people's rights. And I would encourage her to say something about this too. So when we think about MRG's work in the context of this debate, how do we bridge it, Felix? You asked us in the question. And I also want to thank Emily who framed these questions. First of all, we see human rights as are ultimately focused on protecting the inherent dignity and worth of every individual. That's the fundamental goal. Let's not misinterpret the roots to that goal, the lex specialis that have been created in international law for women, for migrants, for refugees, for minorities, for indigenous peoples, for the stateless. Let's not assume that the attempt to create a lex specialis towards that goal is the problem. Let's not assume that in a sense, distracts us from the universality of rights. And I think that is very, very important because in those goals, what each of those regimes is trying to do, including our regime on minority rights, is do no more than provide access to the kinds of fruits that exist in trying to protect the inherent dignity and worth of every individual. So that is really our starting point. And then you might say, yes, but then what about, Yanis pointed this challenge out, because Yanis knows this well from Austria's support for these issues. LGBT, gender, all of these are issues that are on the table. Security is now becoming an increasing threat. How do we then take that simple idea and apply it in these contexts where, in a sense, in other colonialism, the rubber meets the road? How does that happen in actual practice? And in actual practice, what we do is we do a bit of a power mapping to understand what it is that the needs of the community are. And then we try and understand from that perspective what interventions would be necessary on the ground to be able to make that a reality in a real sense. What that means, we all know, I think, on this, it means trying to make the necessary administrative, legislative, and judicial changes that will provide real meaning and bite to the rights that have been expressed in a normative framework at Geneva and other places. And that real challenge of trying to address those issues necessarily means speaking to power, sometimes contesting power, sometimes challenging power, sometimes ridiculing power, but often it also means working alongside power to be able to make the necessary changes to get the world that we all believe in, where the inherent dignity and worth of every individual, especially those who are far from sites of power, can be realized. So that is very much our take on how we do this. And I think that in a sense, there is a risk here. And the risk is that the one-size-fits-all approach. We still have this. I do this exercise a lot in the teaching I do, and in varied places like my own much more humble University of Middlesex, but also in exalted places like Oxford and others where I teach. I asked people to name me 10 states in the Pacific, and they can't do it. They can't do it not because they're stupid colleagues. They can't do it because we still see that map with Europe in the middle, and we see the Pacific Island states as little dots on the corner that we don't really have to pay attention to. And that is really very much our perspective. So we have to avoid a one-size-fits-all universality. At MRG, we are now approaching a 17-region approach. We've discounted the idea of the 5 continents because, again, that's a nonsense. Asia by itself is 57% of the world's population. Then when you add on the Pacific, that adds on the complexities, not many numbers, but it adds on complexities. So we've discarded that notion. We think instead in terms of regions. And the 17 regions that we think about actually have shared experiences of colonization, of conflict, including inter-community conflict. But in trying to frame our understanding, we are also trying to arrive at the fact that many regions are incredibly diverse. You take South Asia, which is where I come from, and if you take South Asia as a region, Muslims are not necessarily as vulnerable a minority as they might seem in India, and Hindus are not as vulnerable a minority as they may seem in Pakistan. So we're thinking in the regional context helps us to frame interventions and helps us to engage with this direct question of what does it mean in terms of LGBT rights? What does it mean in terms of gender? And our approach is very simple. We believe in the universality of rights, and we believe that whatever we do are roots to being able to realize and practice what those rights mean for an individual who's far from sites of power. We accept the fact that there will be nuances and ideas elsewhere, but we also try to promote the fact that those nuances that you call culture are in fact a culture of one kind, a culture of dominance. And the culture of dominance that has effectively prevented women's voices from being heard within communities is also a culture, but it's not a culture that's in line with human rights principles, because we do not think that the accident of birth of an individual in terms of their gender should determine their access to the rights that they have. So on gender, we can be very much more aggressive, perhaps. And what we find is that in many minority communities, it is the women's voices we want to hear, because it's the intersectional discrimination that applies to women, LGBT, and others that really is the challenge we have to overcome. It's not so much the challenge for the privileged male within a minority setting. That challenge has been articulated and those rights have been gained. Yes, we're losing them in various places, but if we want system change, we have to address the rights of the person within the community that's most vulnerable. So we try to engage in this particular way without, of course, being preachy about it, because we do not want to be accused of the white saviorism that I think is a fair comment for any comment based in for any organization based in the North that seeks to work in the South. So essentially, I leave you with how to bridge the gap. I would say, first of all, we need specific design for specific projects, for specific aims. No general comment. We all know what the general comments are. We all know what the normative standards are, and no amount of reiterating them to each other will make any change on the ground. So we think in terms of how a specific education system can be designed with linguistic rights promoted. When we think about that, we don't just think about the language of the education, we also think about the content of the education and the extent to which it marginalizes certain identities, and by that way, delegitimizes the existence of other languages in a given territory. We think beyond the historic value we think beyond the rhetorical value and to the point of intervention. And when we think about interventions, we actually try to draw a power map of what are the kinds of issues in the way of getting this reality and how do we need to influence them. And then we employ a range of different tools to try and address that. But I think at the fundamental level, I would encourage us to think more as human rights lawyers about the value of administrative law. We often think legislative and judicial. We are often trying to convince the judiciary to change its views, or we're often trying to get the state to pass legislation. But colleagues, in a world that's moving towards increased majoritarianism, the chance that we'll have access to legislative powers are getting less. So we need to try and win the little wins. And we found it's easier to work at local authority level, where a local authority is not setting out its education policy to exclude somebody. It just doesn't have the imagination to be able to include them. So we work with that, and we often find that under the radar at administrative law level, it's often possible to make significant advances to our agenda that when you try to elevate them to a legislative or judicial perspective, end up becoming political issues where the use of artificial majorities now is actually grown on the back of creating scapegoats who are often minorities. So with that, I would really call on you to endorse Fernand's challenge. Let's tackle this universality issue and this attempt to put this universality question towards minority rights. Let's dismiss it, but let's dismiss it with authority. And let's make sure that essentially we focus on the fact that human rights mechanisms are designed to promote the inherent dignity and worth of every individual, and that anything that gets in that particular way is essentially to be studied and to be addressed, but that if we don't create lex specialis of the kind that we are familiar with, we will not be able to get significant communities of the world access to the rights that we promised them that collectively as an international community in 1948 and onwards. Thank you very much.
Thank you. Thank you very much, Joshua, for your intervention and for the very pragmatic ways also that you point out in, first also deconstructing concepts and criticisms, but then really about how to realize universality via specific ways actually in that particular and peculiar context. So thank you very much for that. And I would like to open the discussion now. For those online with us today, you may raise your electronic hand or contact us in the chat. Please, if it's possible, do switch on your camera when you're speaking. So and do briefly introduce yourselves. We have about 20 minutes left for the discussions. So I'd invite a number of comments and questions first, and then obviously would like to get back and give some time to each of the panelists also again to react. So with this, the floor is open, and I see a first request here by Catherine. Catherine, please.
Hi, first of all, thank you very much for accepting me to this meeting, and thank you so much for elaborate more on these topics. I have a question on what we can do as a minor society with a non-political background to participate and contribute to human rights. I would love to get more involved. I just don't really know how I can do it.
Thank you very much. And I see, yes, Alexandra Xantaki, you were mentioned already. Congratulations also to your election as Special Rapporteur, and the floor over to you, please.
Hello, good morning, and thank you very much, and thank you for your wishes. I find this debate really, really necessary because, as Joshua very well said, we really are at a point where the so-called universalism, because as Fernand said, it is not really what the concept is about, the way it is currently interpreted, is putting in danger the successes and the conquest that we have made in human rights. And so I have also, as an academic, I have also written on this. So, in the new UN Special Rapporteur on cultural rights, you definitely, in the field of cultural rights, I still have to say it correctly, you really have a firm supporter on promoting a better understanding of universalism, and also taking into account first of all, particularities, but especially also promoting the special measures, so the provisions that in various instruments that are also legally binding, that not only allow states to take special measures, but also oblige states to take special measures when circumstances warrant. I just wanted to, because we're having a pragmatic discussion, I just wanted to ask whether how you feel that from the United Nations, the special procedures can help the UN Special Rapporteur on Minorities and the civil society to tackle this. Is it better to indirectly always promote this and always as an issue indirectly, or is it better to go, as I think Joshua said, to go straight on and actually very directly discuss about this? Especially in view of the fact that in my mandate, there has been a report on universalism that I'm not sure it is fully in sync with the debate that we've been having now. Thank you.
Thank you very much. Thank you for joining the meeting and also for your intervention question. At the moment, I do not see further requests for the floor, but would like to encourage people to take the floor if you'd like to comment or ask questions, because I think in seeing the time, we might only do one round and give the possibility, obviously, to all the speakers to comment again. So not sure we come to a second round. So I'd encourage you to raise your electronic hand now, or just let us know via the chat if you have comments or questions. Just quickly looking through my list here again at the moment. Yes, I see Miriam Minder, please.
Thank you so much, and thank you a lot for organizing and holding this meeting, and for the very interesting debate we're having and discussion. I'd be interested in the panelists' experience in how discussing minority issues with states and state representatives, especially when it comes to foster consensus on delicate issues. My question would be, what are the lessons learned from these discussions, and how can difficult minority issues be discussed within the Human Rights Council and minority questions? Maybe I haven't introduced myself, sorry for not having done so. Miriam Minder from the Federal Department of Foreign Affairs, working with the Directorate of International Law in Bern. Thank you so much.
Thank you very much, Miriam, for your question. And I think also, well, two speakers at least have already touched upon the political consensus building. So I'm sure we'll come back to that also in the discussion. Thank you very much for that question. Do we have further requests for the floor? So just that I don't ignore anyone who is without a camera. Sorry for that, just looking through. So I don't see further requests for the floor right now. And thus would like to give it back in the remaining 15 minutes to our panelists to react to each other's interventions, but also then to the questions from the floor of how to advocate for human rights how so-called universalism puts in danger the gains of human rights protection. And I think also the two last questions there resound, I think, in terms of direct advocacy, indirect advocacy, consensus building, as mentioned before, also by Yanis with that consensus approach in the council. So I think there is also maybe something you might reflect on also in terms of how a discourse and a debate in the political setting of the Human Rights Council might also be different, maybe to some discourse with a national government directly, or also in a regional setting. So I think there might also be dynamics to look at. If I can go again in the same order as you were speaking before with your interventions, and ask Alexandra first to take the floor on those questions and any further comments that you'd like to do.
Thank you, Felix. In fact, I don't think I'm in a position to answer, unfortunately, these questions, because my own practice as a lawyer and a scholar is not directly engaging with the UN. So rather, I would add to the questions that have been asked from the other panelists who have much more experience from this perspective. What are their views on engaging with China on these issues? I can see that somewhat from within the discourses, seeing how various actors with various minority linguistic groups' interests at heart can engage with the state, but I don't really have any visibility on how that happens, from one state to the other, or from international organizations to China.
Thank you very much. Thanks for that addition. And so then I'll move over to Yanis. Let's see what you'd like to say also on that last point just raised now. Yanis, over to you.
Thank you very much, Felix. And I should say that all the interventions have been particularly thought-provoking and inspiring. I wouldn't know where to start, actually. But what I would like to say in the beginning is that the very purpose of multilateralism is to foster dialogue and to try to bridge such disagreements that we have. And even though progress is very, very slow, the very fact that we have this forum in which we can sit together and put the differences on the table, identify what they are, and slowly try to address them when the political stars are aligned is already something very, very valuable. And in that sense, we need to be very cautious and vigilant against any efforts to undermine multilateralism. Felix, you have mentioned it in one of your reactions to my first intervention, that there are increased concerted efforts of like introducing new narratives, and these type of exceptionalisms are more and more prevalent, and I think the first point is that we need to push against that. The second point I would like to make is that we don't necessarily need to reinvent the wheel on those questions on universality. As you said, like already during the time of the negotiations of the Universal Declaration, and also much later during the Vienna Declaration, the negotiations of the Vienna Declaration, these discussions have already been had since then, since 30 years now. And if you look at the Vienna Declaration, you will see that it is a very delicate compromise, actually, in which I believe that most governments can still today identify themselves to a certain extent. And also the formulation on the universality in that document is very carefully drafted. So we do not need to necessarily reinvent the wheel. The third point I would like to make is that it's absolutely essential in a way to empower individuals to know what their rights are, and to also be in a position to claim them to a certain extent. And this brings me also back to the participation of stakeholders at the United Nations debates. this goes beyond minorities. It's also civil society. It's more and more businesses. The way decisions are made have changed, and the actors are changing, and these new actors need to be involved as well in the discussions if we want to be accurate to the times in which we live in. With regard to how to approach sensitive issues, I think compromise is always very, very important, of course, in these contexts. And there is a lot of merit sometimes in a sort of silent diplomacy as well, which of course should never exclude the possibility of also openly speaking about topics and do what several states who, as I said previously, oppose mentioning concrete country situations call naming and shaming. But there is a sort of gradual approach that should be taken, and it also depends very much on our interlocutors and understanding what works for some might not necessarily work for others always. So this is something which is important to bear in mind as well. With regard to the question on how to participate at the United Nations, I would, as a start, definitely encourage that you sign up to the Minority Forum, which is taking place tomorrow and the day after. I think for anybody who hasn't had exposure to the UN, this provides really a very good indication of how the UN works and an insight into the challenges that we have and the differences that occur among states. So I would definitely encourage that as a first step. But we are very conscious of the fact that we need to enhance our ability at the United Nations to make our work more accessible to the general populations. And even though many of the deliberations that are happening, for instance, the interactive dialogues with the special rapporteurs are webcasted, so they're available online. I doubt anybody knows that and actually watches them. So I think already spreading this type of information is something that could serve as a first step into the world of the UN to a certain extent. I will leave it at that. Thank you very much again.
Thank you very much, Yanis, and let me turn to Fernand, please.
Thank you very much. First, a response to Miriam Minder's question, vielen Dank. I think we have to get back to basics when we talk about also the human rights of minorities. And human rights. Human rights, one of the fundamental principles behind human rights is peace and stability, and through justice. And this is actually for all participants, all those involved in the international community and states. This is something that I think has been forgotten recently. And I say it's been forgotten because we are seeing increasingly disregard for the human rights of minorities. And I just want to very quickly mention this. First of all, the number of conflicts involving minorities in the world in recent decades have increased. Secondly, the number of minorities who are stateless, the number of persons belonging to minorities who are stateless has been increasing in the last 5-6 years. In large part because, for example, in India, in Assam, we have situations where there are millions or more than 1 million individuals, mainly belonging to Muslim and Bengali minorities, whose citizenship is being denied. Thirdly, we are seeing an increase, significant increase in hate speech in social media targeting minorities specifically. In countries where we have disaggregated data, it shows that about almost around 3/4 of the targets of hate speech in social media are in fact minorities. Additionally, in the area of language and education, a significant number of countries are not only restricting, but actually in some cases actually eliminating education in minority languages through the minority languages medium of instruction. The world is actually getting a darker and nastier place, and mainly because minorities are being targeted in different regions. And I think we've forgotten that. We have forgotten that unless we protect fully the human rights of all, particularly those that are marginalized and vulnerable, such as minorities, and particularly women minorities, by the way, has been mentioned by Joshua previously, we are not going to achieve stability or peace that is needed, in fact, in order to actually have prosperous societies everywhere. The lessons seem to have been forgotten. I want to mention very quickly the first joint study by the World Bank and the United Nations called Pathways for Peace, which actually pointed out that it is when you deny human rights, although their language was a little bit, how would I say, generalized. When you deny, when you cannot respond to the grievances of groups, minority groups mainly, in terms of not only justice, but actually claims of discrimination and exclusion, you actually have unstable societies, and in fact also violence, violent conflict. So I think we have to go back to basics. The human rights for all and the universalism of human rights is actually not being applied. And to link up to the lex specialis, which Joshua referred earlier, I think this is a clear indication that we need stronger instruments to protect the human rights of minorities around the world, because this is actually not occurring. A last example, a concrete example, is the rejection by the European Union's Commission of the proposal for a minority safe pack, an agreement and various measures to protect the rights of national minorities in Europe. The European Commission completely rejected this as saying it is not necessary for Europe because the rights of minorities are perfectly protected. And that is clearly not the case, to use rather diplomatic words. And to Catherine as to how she could be more active in the area of the minority protection, there are two levels. As Yanis said, there is the UN forum beginning tomorrow, but it is too late to register for that. But I would say nationally and internationally, locally, nationally, internationally, locally and nationally, please get involved in minority activities in your area and minority and human rights organizations. At the more regional and international level, there is the Minority Forum at the United Nations, but the regional forums are also organized under my mandate in 4 different regions of the world. I assume you're in Europe, so we do have a European regional forum also. I'll stop there because time is running short.
Thank you very much, Fernand. Thank you also for the practical advice also on engaging, indeed also including on the national level where human rights start after all. So I would like to give the floor now to Joshua also to react to the comments and add also reflections you might want to do. Joshua, over to you.
Thank you, Felix. So in turn then, I mean, just to build on what Fernand and Yanis said, Katrina, it's great that people are getting interested in this mandate, and we need more people, and we need you as an actor to take responsibility for working in this area and for shaping this area. So we're delighted that you are interested in this and really encourage you to do as Fernand and Yanis have suggested and get involved. To Alex, I guess 2 points to you in terms of cultural rights. I mean, one is a kind of offensive and one is a defensive mechanism, if you want to call it. On the offensive side, there has been a tendency for cultural rights to be seen from an extremely elite lens. So culture is what happens in theaters and in operas and other places, and it doesn't really happen elsewhere. That itself has been incredibly exclusivist and incredibly majoritarian. And I think that tackling that is fundamental to experiencing and to understanding how culture can be seen in different places and different lenses, and it looks different. And actually, that's the marvel of culture, that's the diversity element of it. So I think that is something that I'd really hope that your mandate will develop as you go forward. The other side of that is, of course, the more positive one, which is validating particular communities' work as culture. So one is to try and change the edifice, to break those edifices. And I think we worked quite well with your predecessor as well on some of those aspects, but the other is building something to replace it. And I think this is where the cultural rights sphere can play a major difference, because very often in the world of engaging with minorities, indigenous peoples are just seen as victims. And all we are doing is to try and address their victimhood. We're not really promoting the incredible values and incredible perspectives that they have. And I think cultural rights we tend to, again, it's a mass generalization, but many of the people we tend to work with have a more proactive and positive and progressive view of what their societies can be. So we found it easier to work with artists all over the world, even from majority communities. And so trying to build on that, hooking minority cultural, I guess, like people who are from that cultural rights sphere, whether they call themselves that or not, hooking them into that movement is going to be very, very useful for both objectives. So I really look forward to working with your mandate on developing those elements. Miriam, great question. And I think I would go along the similar lines that Yanis and Fernand took on this. We are essentially in 2021 poised at a situation not dissimilar to the situation that we faced in 1938, 39, 40, in terms of the growth of populist movements and their ability to take over states based on an ideology of scapegoating someone else. This is not a prediction of doom. I don't want that narrative to play out like it did from 1938 onwards, but we who are working in the peace and security area and the conflict prevention area need to understand the inherent threat that exists of that happening. And we need to have learned our lessons from history to be able to take proactive steps. So part of this reiterates what Yanis said earlier about Austria's leadership in terms of the UN General Assembly and the move to recognize the fact that what we are facing is an inherent threat to the dignity and worth of individuals, but also the potential that majorities will sweep to power based on scapegoating, because that's the politics we have. The politics that we have in many of the countries we work with, you end up seeing a narrative that's expressed, not a narrative that particularly has any value, but that tries to generate an artificial majority. And then you get an artificial majority by scapegoating. You know, if this was a playground and there were 10 children in the playground and one of them is disabled, instead of trying to figure out how you should regulate the playground, you point to the other 9 that they have something in common, that they are not disabled. Then you use majority as a game of numbers to win the argument that you should be king for the day. But to maintain your kingship for the day, you have to keep scapegoating the 10th disabled kid. And that's the politics we have. And what it's given us is mediocrity. And the pandemic shows this. At a time when we are most challenged by the permanent environmental crisis and the temporary, I hope, pandemic crisis, we have the least able people to be able to determine it. Because you essentially just got the kid who told you he'd buy ice cream. And so those kids are now in power. And yeah, the ice cream that they hope they give you has melted, and they don't have any idea to the existential threat that societies face. So we have to reiterate the hearts and minds argument to be able to explain that this is about trying to create a politics of inclusion, but it's not an inclusion because we like minorities. It's a pragmatic approach. If we don't do this, we run the risk of creating and reiterating mediocre people to get into these kinds of leadership positions, to then not have a policy on where their states should go. And I think this is important at the UN and Security Council level, but it's also important in civil society. And this is certainly what I'd endorse that call. Alex, great question. I mean, you know this much more than anybody else does. China has the longest documented history. I have something of a Sinophile. I've worked on the European Union, China, diplomatic and expert dialogue, ran a workshop in Kunming in 2003 that focused on the 55 minority nationalities, or Minshu in the Chinese context. And I think the key here goes back to the start of this conversation. It's to do with the way in which we in the international society have engaged with China and in terms of the human rights debate. There's been a lot of finger wagging, and there's been a lot of and in the Chinese context, the notion of long-nosed barbarians telling an ancient culture about how to behave is a huge challenge. So we got the tone on that very, very badly wrong. And I saw certainly a progressive period between 2003 and 2018, where there was a real awareness of the need, based on original documents of the Chinese Communist Party, and based on subsequent white papers, and based on subsequent, even the constitution, where essentially the idea of uniting China as a family of nations to overcome the so-called Han chauvinism was a key. And I think that provided us with a huge impetus in terms of building minority mechanisms and learning from some of the Chinese models, which have now been lost in the context of a general finger wagging against China. So my suggestion is more engagement to a pragmatic. Chinese policy is pragmatic. If you read Chinese history, of course, and you, of course, Alex, have in your work, you will see that the idea that a movement can sweep to power and undermine the state is not new in Chinese history. So it's not strange that China fears a movement that might do exactly that, using identity or any other Trojan horse to do it. So it's understandable that that's a fear. But trying to explain that the pragmatism of engagement is actually the only way to overcome that fear and not a repression. I did an article that you might want to look up in the Chinese Journal of Comparative Law. I think it was published last year, which is titled The Rise of Majorities. It compares India and China, and it basically tries to make this particular point. It makes the point that in both states, and there's incredible parallels, even in terms of timelines, India 1947, China 1949, incredible parallels throughout. What you actually see is an early thinking among the intellectuals that the only way in which these two very large states that are 2/6 of the world population, a little bit more than that, very, very significant understanding drawn from their own culture and drawn from their own interpretation and their own lived experiences, that the only way to build peaceful societies was inclusion. Now we see that that has been undermined, and I would argue, to my previous answer to Miriam's question, it's been undermined by populists who are just seeking to gain control of the bus. They don't know where they want to drive it to. They just want to gain control of the bus. And so in a sense, there are incredible layers of very, very progressive elements who really believe in the future of all the communities that live in these two states. And finding a way to engage with them is important. But to do that, we have to take away what Yanis talked about, this idea that somehow minorities are a threat. They're not a threat, but in fact, playing up their levels of threat might give you the kind of existential realities you think minorities can achieve, which you are now doing yourself. And that's what that piece argues. So my argument on China is more engagement. It has got me into trouble, but it is my argument nonetheless. I still believe that greater engagement is the only way to do it. And finger wagging and downplaying is just not a way to do it.
Thank you very much, Joshua. Thank you for that advocacy for the pragmatism of engagement with a specific country, but I guess across countries. So on that note, I would like to close this today's human rights conversation, thanking all of you, thanking you, the panelists, participants, for your interventions, questions, and comments. Also would like to thank my colleague Emily Max, who is actually conducting the research project here at the Academy on Universality, and who has also prepared this event today. And last but not least, also thank the Swiss Confederation for the support to the research and activities here at the platform and the Academy. That is very much valued. Thank you, all of you. And as mentioned before, this event was recorded. It will be posted online. And also, if you want to be kept informed about other upcoming human rights conversations and other activities over here at the Geneva Human Rights Platform, please do also register to our newsletters. And I very much hope to stay in contact, as this project is also ongoing here at the Academy, and we're very grateful for your input, because beyond the great discussion also that we had and the individual ideas of how to take things forward, we'll obviously also pick up that wisdom in the documentation that we'll be putting out as of the beginning of next year. So thank you all again very much. Thank you for your participation, and I wish you all the best also, including a successful forum in the coming days. Thank you very much. And with this, I'm closing our meeting today. Thank you and goodbye.
Thank you very much.